Okay. I think that's, I can't actually see on the screen, but that's okay. I want to go ahead and welcome everyone. My name is Deborah Pearlstein. I'm a professor here, and I co-direct, along with Professor Pollack, the Floersheimer Center for Constitutional Democracy, where we put on events like these, among other things, to help us better understand what's going on in the world and how the law is playing out, even as we study it here in the classroom. I want to thank, before we get started, our incredible administrator, Wei Yang, who is indispensable to the Floersheimer Center's operations. I especially also want to thank our student fellow, Abby Strange, who has been wonderful in helping us put this particular event together. And I also want to thank, on this occasion, the Wisconsin Law School State Democracy Research Initiative, which is a tremendous resource and doing a lot of interesting work in this space, and co-sponsoring this particular event. Adam Sopko, who's a staff attorney with SDRI, I should say, is here with us all the way from New Jersey, where he has been most recently. So thanks to everyone. I want to say just a super few words about why we wanted to do this particular panel. So litigation over election and voting rights has been around for a long time. And in election years, there is always a huge uptick in litigation over elections and voting rights, election challenges and districting issues and all kinds of things. But this year, in an off year, right, and thanks to the Brennan Center for the statistics, there is ongoing litigation over one issue or another in 31 different states, including still 73 pending redistricting cases. So these are cases challenging districting on political gerrymandering grounds, racial gerrymandering grounds, and others. Some of these cases are in federal courts, but a huge number of these cases are in state courts, playing out in very consequential ways. And there are orders, there have been orders in state courts. Speaking of state courts, I'll come right back to that. In Alaska and Maryland and New York and Ohio and North Carolina and South Carolina that have ordered essentially redrawing the maps after the legislature or some other body drew them in the first place on the grounds that they violate some provision or another of state law. So there are two questions here, or at least a couple of questions. I'm going to actually ask a lot more than that, but there are two big picture questions that I want to ask. And one is what's going on? Is this some significant change from how things used to be? And if so, why? But also then specifically, how should we feel about the role of state courts and state court involvement in essence, federal elections, in really consequential state court involvement in how we run federal elections for Congress, for the presidency? Obviously, the stakes are enormously high. So that's just me clearing my throat. What I really want to do is ask the folks who do this for a living, and it's this extraordinary panel. So I'm just going to introduce them super briefly. Their full bios, of course, are online, but I really can't picture actually a better group of people to have this conversation with. So let me start with Ethan Herrenstein. Are you Stein or Steen?
Steen, but it's a 50-50 guess. You never know.
It is. I know this conversation well. You made the wrong choice, but we can talk about that later. So Ethan is counsel at the Brennan Center over at NYU Law, where he serves on the democracy programs, voting rights, and election team. And in addition to work on voting rights litigation and policy advocacy, he's focused most recently quite a bit of attention on this independent state legislature theory, which is the subject of a pending case in front of the Supreme Court, in which I know we will all talk about more today. So thank you very much for joining us from a practice point of view. Professor Rick Pildes here is the Sudler Family Professor of Constitutional Law at NYU, where he also teaches election law and courses on presidential democracy and others. And in addition to dozens of articles on this and lots of related topics, Professor Pildes is the author of a leading case book on U.S. election law, which is called The Law of Democracy. So if you ever take a straight up election law course, you may see his case book on your desk. Among his many honors, he served last year on the President's Commission for Supreme Court Reform. I think that's what it was called.
President's Commission on the Supreme Court of the United States.
That's the one.
Didn't want to load the deck.
No,
In the title.
The question for the President's Commission on the Supreme Court of the United States was, should we engage in any form of Supreme Court reform? And there's an important report that was issued by that commission. But again, most recently, or among most recently, testified before Congress last year on this independent state legislature theory, which we will talk about more as well. Professor Carolyn Shapiro is the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States and associate dean at the Chicago-Kent School of Law. She teaches also constitutional law, statutory interpretation, and other classes, and has written extensively on a variety of institutions of constitutional democracy, and also among her most recent writings was part of an amicus brief of scholars in Moore versus Harper case, which is pending in front of the Supreme Court. Between, I should add, 2014 and 2016, she also served as Solicitor General of the state of Illinois while on leave from her law professor duties. So she can speak from both sides of the practice divide. And speaking of the practice divide, thank you so much for braving traffic. And
sorry, I was late.
Your
Even appellate litigation doesn't.
Absolutely. And your timing is actually perfect, as it turns out. Number one, you're helping us understand what practice life is more like as opposed to academic life. This is Judith Vail, who is the Deputy Solicitor General here of the great state of New York in the New York Attorney General's office. And among other cases, she has worked on amicus briefs for more than a dozen state attorneys general in cases involving voting rights and redistricting in the Supreme Court, in addition to doing lots of, obviously, litigation here in the state of New York. Before she joined the AG's office, you were at Davis Polk, yes, and also you clerked on the SDNY for Ken Karras, in addition to clerking on the Second Circuit. So experience across the sort of New York law practice universe, which is wonderful. Thank you all so much for coming. Okay, so enough. I want to start with a question for each of you to just help us all come up to speed on what we're talking about and what's going on. But then I want to have as much of a conversation as possible. So please feel free to respond to each other and to me. So Rick, if I can, let me just start with you and ask us to help put in perspective the current moment which we find ourselves. Why is there so much ongoing litigation in the courts over this? Why in the state courts? What's going on in our particular moment?
Well, from a big picture perspective, I think there are 3 or 4 things to kind of notice that provide the context for all of this. One is that partisan control of the House or the Senate or the White House has been more up for grabs in every election over the last 30 or so years than in any extended period of time like that before in US history. So we're living in this world in which each election, it looks like one of those 3 bodies could change partisan hands. Second, many people on both sides have come to believe, rightly or wrongly, that elections are now sort of existential, meaning if the other side wins, the country will never be the same. The changes will be irreversible. The third thing, as a result of those 2, is that many people have also come to believe that each individual issue in the voting policy space is itself kind of existential. After we had the Bush v. Gore election in 2000, which in a kind of surreal fashion turned on 533 votes in Florida, which is when a lot of this litigation started ticking up in the aftermath of that, it was the case that very small margins could conceivably affect the outcome. And then I think the last thing I would say is, especially since 2016, there's been a tremendous proliferation of groups that are organized around voting issues and litigation on voting issues. There's been a tremendous inflow of resources to litigate these cases. And I think that also, kind of contributes to this overall situation in which, pretty much every dispute about every particular issue on voting policy finds its way into federal or state court. Not everything, of course, but an extraordinary number of issues.
Absolutely. I think that's right. And there are probably more things so folks can pick up on that as well, but it covers a lot of territory and some of which I want to be sure to return to. Let me just to make this a little bit more concrete though, right? So we've had here in New York, for example, pretty consequential districting litigation just recently. I wonder, Judy, can I ask you to just tell us a little bit about like what was this case? What were the issues? How did this play?
So I'll preface this also, of course, with the general caveat, everything I say here is my own personal view. I'm not here on behalf of the Attorney General's office. I also didn't actually, for better or worse, I didn't personally do this litigation. It was filed upstate, and so it was handled by our Deputy Solicitor General upstate. However, it was obviously a very big deal, and I'll talk a little bit about what happened. So the Harkin Rider litigation and decision kind of all stemmed out of two things. Basically, there was a New York State constitutional amendment in 2014, which put sort of a new redistricting system and rules in place for New York State. And this amendment, it was a constitutional amendment, created an independent redistricting commission that is set up to be bipartisan. And so both in its structure and in the amount of votes that are needed, depending on which parties could either control both houses or not. It was sort of set up so that it wouldn't be so easy for either party to have control over this independent redistricting commission. And in addition to creating the commission, the constitutional amendment set up a process whereby to do the redistricting that needs to happen every 10 years after the census, it would be the commission that would need to at least do the first and then second crack at maps. So the commission needs to do a first crack at drawing the maps, submit that to the legislature, and the legislature needs to vote up or down on that. If the legislature rejected it, then the commission would have to take a second crack, give that to the legislature. Legislature is supposed to vote up and down on that. And only after that, then the legislature could start, if there was another no, the legislature could start doing amendments to the second plan to try to get something in place. And the constitutional amendment also prohibited, as a matter of state constitutional law, partisan and also racial gerrymandering, and there are other rules as well that I think are less relevant for this particular case that happened. So after the 2020 census, we sort of embarked on the first application of these new constitutional provisions, and perhaps inevitably it ended in a big litigation. The commission really couldn't come to agree on either a first set of maps, and so they submitted two different sets of maps to the legislature, neither of which passed. And then the commission couldn't agree on a second proposal to submit to the legislature. And so there was sort of a question as to like what even happens then. And the legislature had predicted that such deadlock might happen and had actually passed a statute saying that if this sort of deadlock happened and that a map wasn't even submitted to the legislature, then the legislature would just draw the map itself and sort of retained its inherent authority to do that. And so that's what happened. And the legislature drew both congressional and state Senate and Assembly maps, and those were challenged in state court, and it went very, very quickly on just an incredibly quick litigation case up to the New York Court of Appeals, where the majority of the court, it was a decision that had some dissent, but the majority struck down the congressional and the state Senate maps. The Assembly maps kind of ended up in their own place because they hadn't been challenged, and they ended up in their own litigation, and so they ended up sort of going in their own path. But the New York Court of Appeals majority struck down both the congressional and the state Senate maps, saying that the process had not been followed. The constitutional process was not followed because in the court's view, it was required that the commission submit a first bite and then a second bite at the maps before the legislature could do something. And since that process hadn't been followed, they said that the maps were not constitutional. And then the court also went on to rule that the congressional maps were unconstitutionally politically gerrymandered. And there was some question as to whether they even needed to reach that question since they had struck down the map on a process claim. But they did say that they thought it still needed to be decided, in part because the remedy, what to do after the maps were struck down, was a big issue because the maps needed to be drawn in order for people to know which districts to run in order for people to vote. And so the court ruled also that there was a partisan gerrymander. There's not a ton of reasoning in the majority's opinion on that. There had been a trial, a bench trial. The state trial court had said there was a partisan gerrymander, and the Court of Appeals sort of said, you know, as the appellate court, there's a very high standard for overruling fact finding, and they decided there was enough evidence to sustain that ruling. And then the remedy and like what would happen was a very big deal in this case, because there was supposed to be primary in June, and there really just wasn't enough time to do it before June. And there was, you know, a lot of question about what should happen, and some arguments were made that the maps should just be left in place for that upcoming, you know, this upcoming election, and then, you know, deal with it for the next one. But what the court ended up doing was saying, you're gonna split. So what ended up happening was they split the primary. So the state assembly primaries that would happen in June as planned, and there was a separate August primary for the congressional and state senate, and there had to be a whole redistricting map process done, and it ended up being done with the supervision of a special master back in the state trial court.
Thank you. So, so in other words, right, this is right up to the edge of elections repeatedly. And ultimately we see the outcome, I guess, the state court drawn map in the midterm elections, right, coming out of New York, which shifts power in some significant ways. Okay, so that's one example of one of these, you know, dozens of cases that are currently pending that has some pretty immediate political consequences. So what is this Supreme Court case, and how much does it affect these issues? And I guess help us understand what the sort of political valence, if there is one, by which I mean, you know, what's at stake here?
Well, so I'm going to start, if that's okay, by just taking a little bit of a step back and saying just a few very broad strokes about how elections are generally regulated, which is complicated. But the baseline, the sort of the default idea is that states are in charge of elections. They're certainly in charge of state elections. They're in charge of making laws that govern local elections. But they're also, the default is, make a lot of decisions about federal elections. Not all decisions, but the Constitution says in Article 1 that state legislatures shall decide the time, place, and manner of congressional elections. We'll come back to that. Congress can pass its own laws that override what states do. So, for example, the reason we have single-member districts around the country for Congress is because there's a congressional statute that says that. With respect to presidential elections, there's a similar language in Article 2 of the Constitution that says states shall appoint in such manner determined by their state legislatures presidential electors. In every state, as you all undoubtedly know, that's done by popular election. So those are the sort of the basic beginning understandings of how states have control. There are additional federal controls that arise from the Equal Protection Clause, the 15th Amendment, the 14th Amendment, the Voting Rights Act, and other federal statutes, which can override state laws that are inconsistent with them. So that's already you see there's a kind of complicated set of relationships going on. The issue that is currently in front of the U.S. Supreme Court that relates to the story you just heard about New York litigation is a case called Moore versus Harper, and it implicates this thing called the independent state legislature theory. And the idea there is that because Article 1 and Article 2, which I just paraphrased, but close to quoted a few minutes ago, both refer to the state legislature as the body that regulates presidential how presidential electors are chosen and the time, place, manner of congressional elections. Those state legislatures act completely outside any limitations that might be imposed by state constitutions. There are different versions of this theory, so I'm not going to get into all of those ideas. But in the particular case that's in front of the Supreme Court, we have in North Carolina, there was a heavily gerrymandered pro-Republican set of maps, both in the state legislature and for Congress. North Carolina is basically a 50-50 state. The maps drew 4 Democratic districts and 10 Republican districts quite deliberately. And the North Carolina Supreme Court concluded that that kind of extreme partisan gerrymandering violated the North Carolina Constitution. The ISLT proponents, the theories of the proponents of this theory say, well, that the North Carolina Supreme Court can't do that, and it can't rely on the North Carolina Constitution to limit the maps that the legislature adopted for Congress. Leave aside the state legislature, it's not relevant to this particular part of the discussion. But the North Carolina Supreme Court and the North Carolina Constitution can't limit what the North Carolina legislature does when it draws these districts. That's the question that's now in front of the US Supreme Court. I think if the ISLT were to be adopted, especially in its more extreme versions, the result would be chaos. The number of cases we would see and the questions about who gets to decide the results and what happens if the state courts say, for example, it's not all about redistricting. If a state court says it's unconstitutional to have certain types of voter registration requirements. State courts sometimes say that. They say our state constitution precludes certain types of voter registration requirements that are too onerous. Well, under the ISLT theory, under the ISLT, with respect to federal elections, that might be ineffective. So we would have a situation where you might have one set of registration requirements for state elections and another set of registration requirements for federal elections that might be inconsistent. They might actually be contradictory in various ways. And that's just one of a myriad of examples that we could talk about. So the short answer is chaos. I think the slightly longer answer as to what are the implications is that there are likely, it's not entirely clear as a matter of who benefits in the long run as a matter of partisanship, at least when it comes to redistricting. It's not entirely clear. The New York gerrymander that the New York court struck down was a very pro-democratic gerrymander. If the Supreme Court adopts a relatively broad vision of the ISLT, that might not be possible anymore. And there are some pretty blue states, California and New York, for example, not Illinois, where I come from, that have limits on partisan gerrymandering. We have lots of partisan gerrymandering. So those could go away, those limits on partisan gerrymandering. So I don't know in the long run, at least when it comes to redistricting, how it would play out. But in the short run, the way the cases were presented to the US Supreme Court and came up really during the 2020 election, it was very clear that it was Republicans, the Trump campaign, bringing these claims, and they were, I think, viewed widely, and I would say, including by at least some of the justices, through a partisan lens. If the ISLT is adopted, especially in broader strokes for a variety of reasons, we're going to see more and more of these sort of last minute 11th hour types of cases that go to the US Supreme Court with parties saying, litigants saying, the state court got it wrong, you should fix it. And all of those will be on this very fast track emergency basis and will be extremely partisan.
Okay, so now I'm good and worried, although I have other questions. Are you going to make me feel better? But I feel like you're not going to make me feel better. It's like suddenly, Ethan, right now, you at the Brennan Center, which has done work in sort of democracy issues for years and years, are focusing a huge amount of attention on this. Do you share this view? Do you have other worries? What's the?
I'm not sure I'll make you feel better.
Yeah.
I will say reassuringly, judging from the way oral argument went in Moore versus Harper, it's not particularly likely that the most extreme forms of the independent state legislature theory are likely to be embraced. And as we might talk about a little bit later, it's not even obvious that the Supreme Court is going to rule in Moore versus Harper. The case might get dismissed for different reasons about some hijinks that's going on in the state courts right now. Having said that, even if the court adopts a sort of less chaotic version of the independent state legislature theory, there are definitely concerns ahead. And I'll put them into 3 buckets. The first is that there'll be fewer voting rights, or it'll be harder for people to secure their voting rights. And that's because that state courts construing their own state constitutions often do so in ways that are more protective of voting rights than federal courts construing the federal constitution. Partisan gerrymandering is a great example. The US Supreme Court ruled in 2018 in Grucho that federal courts can get involved in partisan gerrymandering claims, but they promised us state courts construing their state constitutions could. And so, unsurprisingly, litigants brought their partisan gerrymandering claims in state court. If now the US Supreme Court turns around and says, actually, when it comes to congressional elections, state courts can't get involved in partisan gerrymandering claims, that would mean that there would be no courts anywhere to bring partisan gerrymandering claims, full stop. And there are other ways in which state courts are more protective of voting rights when they're applying their state constitutions than federal courts are. And there are lots of state constitutional provisions that are more voter friendly than analogous provisions in the federal constitution. Not least among them is the fact that 49 state constitutions expressly protect the right to vote and the federal constitution does not, at least in a direct way. So that's the first concern that I have. The second concern I have is that it would be much harder to run and administer elections. One of the sort of consequences that might emerge from an ISLT ruling, again, it depends on exactly what that ruling is, but what might come out of it is it would say that election officials on the ground have much less discretion to make decisions in running elections. And that if they are making those sorts of decisions, the US Supreme Court or federal courts are going to review them to make sure that they're not inconsistent with what the state legislature might want. Elections are really hard, as we know. And when there are late breaking developments on the ground, we need the election officials on the ground sometimes to make decisions to make it possible to run elections. We saw that obviously in the COVID context. We see it often when there are like inclement weather or like hurricanes. Lots of states empower their governors or their secretaries of states to delay elections or to move polling places or to make those sorts of last minute decisions. The ISLT could constrain or even eliminate the authority for those sorts of election officials to respond in due time. And in addition, depending on how the ISLT is created or what sort of ISLT ruling we get, you might result in, as Caroline was talking about earlier, a sort of 2-tiered election system where federal elections are run under one set of rules and state and local elections are run under a different set of rules. That's going to be confusing for election officials and it'll be confusing for voters, and it's not going to be good. And then finally, the ISLT could create a more fertile ground for what I'll call election sabotage. I want to be crystal clear here. The independent state legislature theory is not a license to coup. It doesn't mean that state legislators are allowed to just send in whatever slate of electors they want, disregarding the popular vote in their state. But it could enable litigation tactics to swing the results of elections. And we saw some of that in the 2020 election. So we could talk a bit more about that as well. But those are the 3 major buckets of concerns that I have about the independent state legislature theory.
That's a terrific summary and a concise one. And so I want to come back to Rick first, but then to open it more broadly. So you're welcome to respond to anything anyone has said so far. But I want to ask in particular, just picking up on Ethan's remark about, right, there's some substantial grounds now that this case, that's Moore versus Harper, might actually be moot, might be meaningfully moot, right? There's a very credible argument that it is. And there were briefs filed just, I think this last week, in which the parties and the government and organizations like Common Cause take very different views on whether the court should go ahead and take the case anyway. So do you want to say, you want to say a word about what those arguments are?
Okay, so the question is whether the court should go ahead and decide the case, because they've taken the case, as you know.
Yeah.
They had oral argument in the case back in December.
Yeah.
There's no doubt they conferenced on the case. They made their initial decisions about how they're going to decide the case. Draft opinions have almost certainly been written. So they're pretty far down the road. And the twist here is that, I don't know how far into the weeds to get, but the North Carolina Supreme Court, which has elections to choose its justices, and I think they run on partisan tickets in North Carolina, had a 4-3 Democratic majority when it decided this case initially and struck down the gerrymander of the congressional districts. Then there was an election. Now that court has, I believe it's a 5-2 Republican majority, and they accepted a motion to rehear a part of the case that had been decided by the prior court that had struck down the congressional gerrymander. This is one of the more procedurally complex postures a case before the court has been in. We actually don't have very clear guidance from precedent about how to manage the situation. But the argument for the court getting rid of the case, and the court actually went out of its way and asked for a supplemental briefing on this question once the North Carolina court agreed to rehear the case. The argument is, would the North Carolina court, when it finally decides this case, end up mooting the whole litigation? Now, my view, and I know Carolyn shares this view because we've chatted about this, it would be very bad for the court and for the election system for the court to avoid deciding this case, because this issue, as you've heard from the commentary, is going to come up in federal elections, including in the 2024 elections, including the presidential election. It's going to come up routinely, but when it comes up in those contexts, it's likely to be in the midst of actual campaigns, and it could be in the presidential campaign. It will be more obvious in some partisan sense which candidate will benefit and which will lose from a ruling from the court. And we need clarity about the issue before we get to that point. It's not as if the court runs away from the case now, the issue is going to disappear. Sometimes that happens, or the issue might not arise for another 10 years. In this context, that's just not realistic. We know this issue is going to be brought up in almost every federal election dispute, which will now have a component of state law at issue, and then this question about the way state law is interpreted and by which state actors, which could implicate now this federal constitutional question about whether they violated the so-called independent legislature theory. So it would be far better for the court not to put itself in the position of resolving this issue in the midst of an actual campaign. It would be far better for the election system to get clarity now, so we know the ground rules under which the 2024 elections are going to take place. My worry is that the way our legal system is structured, a lot of doctrines try to keep the court out of deciding cases until they absolutely have to decide them. The Solicitor General in this case filed this very ambivalent letter with the court saying, well, there isn't really precedent. It would be reasonable to either continue with the case or not, but we sort of think you should get rid of it, dismiss it. And I think that reflects a certain kind of legalistic mindset. Don't decide things unless you absolutely have to. I think that's the wrong mindset in many election contexts, but particularly in this context. We don't want the court deciding this only at the midnight hour when huge stakes might be involved. But there is this ongoing question of whether the court is going to dismiss the case or go ahead and complete the project that it is 75 or 80% down the road with in any event at this point.
Before I ask the next question, do you folks agree that with this, the court should just decide it, right? And just right. So the argument is there's actually on the law a pretty good argument, maybe, that the court has to dismiss it, or is
no? I don't think that's true at all at this point.
Oh,
do you want to respond, or?
Yeah, I mean, if this were an ordinary case, not this big election case, the court would probably dismiss it. I think they would dig it. They wouldn't say that it was moot because it's not moot yet.
Digging is dismiss is improvidently granted.
Dismiss is improvidently granted. Right. We shouldn't have done it in the first place. Sometimes, obviously, it was improvidently granted based on things we didn't know at the time. But okay, I think that's what they would do in an ordinary case. But they wouldn't have to say the case was moot. They could just dismiss it. But this is not an ordinary case. And justices in a number of different separate opinions in this case and in a case out of Pennsylvania from 2020 have said in shadow docket rulings, these aren't the voice of the full court, but they've said this is a really important issue that we have to decide. And including Justice Thomas said in a Pennsylvania case that was still left over from 2020, he said in 2021, we should take this case because we should decide this question. And we should decide this question when it's not in the middle of an election. So I think, and I agree with that. I think they absolutely should decide it, and they absolutely should decide it when we're not in the middle of an election. Do they have to dismiss it? I don't think there's any way that they have to dismiss it. First of all, it's, as Rick said, it's a really super complicated procedural snarl that is very, very interesting. But I will spare you the details because that's not what we're here to talk about. But it's very interesting and very complicated, and there is no clear answer. And second of all, it's the Supreme Court. They don't have to, there are a variety of ways that they have that are legitimate, that are well within the bounds of their discretion not to dismiss this case. So I don't think they have to, and I don't think they will, but it's always very hard to predict.
So let me expand it now to the broader question, which is, I don't know how to feel about whether I want state courts. I don't know how to feel stepping back about the involvement of state courts in these kinds of questions, and indeed the greater involvement of state courts in these kinds of questions, right? So the North Carolina Supreme Court changes hands following a partisan election, right? Now the court wants to probably change the outcome of the case it decided in the first place. We are witnessing in real time this enormously contentious, incredibly well-funded judicial election play out in Wisconsin, in which I think both candidates have made clear, if I win this election, this is what's going to happen in abortion in Wisconsin, and if I don't, this is the stakes, right? In other words, intensely politicized state elections for state courts. Are we better or worse off still, right, with state courts these state courts, right, many of which are elected positions, involved in these election issues? Or would it be better from removing the intense partisan valence to right, notwithstanding the local the short-term chaos that something like an independent state legislature theory would bring? How do we feel about it?
I'll say one thing, which is I think as somebody who practices a lot in the New York State courts, I mean, I think there's something to be said, if you try to say it doesn't really matter. I think there's something to be said for like, it doesn't actually matter whether it's that you think the court leans left or right or really far left or really far right. There's something generally good and helpful about state courts being involved in interpreting their own state constitutions, their own state laws, and their own state agency actions. There are certainly like appropriate times when federal courts step in, when there are federal, when there are federal constitutional rights involved, or when decisions of a high state court might go up to the Supreme Court. But I think as a general matter, there is something very strange to me about the idea of saying that state court shouldn't be the one interpreting its own state constitution and having a say in that. I find that to be a beneficial thing, regardless of which political party is in control of the court or.
I'll make 2 points, and I totally agree with what you just said, but I think one, zooming out a second, the independency legislature theory is not just about state courts, as we were alluding to earlier, and it's important to keep that in mind. Separate and apart from their appropriate role of state courts and federal elections is the question about election officials, governors, secretaries of state, any actor in the entire state that's not a part of the formal state legislature. And so, we can have a conversation about the role of state courts, but it's important to keep in mind that if the ISLT is adopted, it would likely constrain the capacity for these election officials to run federal elections.
Can you just say like another sentence or two about why that is, or how?
So there are, different ways of understanding what this independency legislature theory says. But ultimately, the idea is that because the Constitution uses the word legislature, it's giving some sort of super special federal power to the state legislature, and it's taking it away from any other actor in the state, even if the state constitution would ordinarily give some sort of power to that state actor. So for example, lots of states allow their governors to veto election law, or to veto laws, all laws. And so if a legislature passes a law relating to elections or federal elections in particular, a governor might veto it in the most, completely extreme, unlikely to be adopted form of the independency legislature theory, but this is where the logic sort of goes. A governor might not have that power. Election officials couldn't.
But I'm sorry. I mean, I don't even know why you bring that up. I mean, I said way in advance of this case, there was zero chance the court in this case is going to hold that state governors can't veto federal election laws enacted by the state legislature. No one who's an advocate for this theory has even taken the position that the theory would allow governors, would prohibit governors from vetoing state legislation on federal election law. When the case was argued in the Supreme Court, from the very opening questions in the argument, every justice accepted that governors could continue to veto state election laws in federal election context. So I think there are enough things to be concerned about with this doctrine without what, in my view, kind of raising sort of red herrings that are just really not an issue.
I agree with you, and I preface that that's unlikely. I'm just trying to spell the logic of the independency legislature theory. I agree that the logic is not going to go that far. The more likely result would be, for example, that election officials who are empowered by their state legislature to delay elections in the event of an emergency are either unable to do so, or when they do so, you have not state courts, but federal courts evaluating whether that election official on the ground was making the right decision, which would, have a chilling effect, which would create chaos, which would be confusing. And so that's why I said that that state courts are one part of the equation, but it's not the whole part of the equation. I agree with you that the governor thing is not unlikely to happen, both because the US Supreme Court ruled in the 1930s that, in fact, the governors do have a role to play in federal elections, and that independency legislature theory, to the extent it applies to governors, is just wrong, and because it would just be, monumentally crazy. The second point I would make, though, is one of the reasons why we want state courts involved in federal elections is because, as Caroline talked about earlier, states are the ones that are making these laws. And the entity that interprets and applies state law is the state Supreme Court. Federal courts have enough to worry about, and the courts that have the expertise and the meaning of state law and the meaning of the state constitution are not the federal courts, but are going to be the state courts. And I'll also add that lots of states and lots of state courts apply different interpretive methods than the federal courts do, and that they are tasked by their state constitutions or by their state legislature to interpret laws in ways that the federal courts increasingly would feel is inappropriate. And so I think that the expertise of state courts in interpreting state law and in applying their state constitution better positions them to get involved in the meaning and the application of these election laws than it would be for the federal courts to do it.
I think I'll add a couple of other things. I agree basically with everything that's been said. If you were starting from scratch to design a system, you might not design this system. It's it's just saying, no offense to the framers, but you might do it different.
They're not here. It's
so I'm not but it's the system we've had now for a very long time, and unwinding it, which the ISLT would do to some extent, would produce a lot of chaos. But I also want to sort of zero in on your question about, can we trust state courts? Are they really any good? Some different state courts are different. They have different cultures, different reputations. But I'll just say, for example, in North Carolina, and in Wisconsin, the justices are elected on a statewide basis. And those are both states in which there are about 50-50 states in terms of Democrats and Republicans. And they have heavily gerrymandered state legislatures. So there is a strong argument to be made that statewide elections may actually provide a pro small d democratic check on things that even if there's gerrymandering is permissible, that the legislature might do. So it's one of the arguments that some ISLT proponents have made. Justice Gorsuch said this several times in his opinions in 2020, is that that the legislature is closer to the people and they're more politically accountable, and that's why they should be making these decisions and not the state courts. And I think that's a highly questionable statement. Depends on the state. There may be very good reasons to think state courts are quite democratically accountable and legislatures are not.
One more thing to add to that is also just the incredible variety of the way states do elections, and even the way what their constitutions say about elections, even the way they amend their constitutions. I mean, I just think the just breadth of the ways that states do elections is really quite remarkable. And, you know, usually that's, although maybe it makes for a very complicated election administration system, if you look at it, especially nationwide, that's kind of, you know, federalism at its best, if you believe in it. And so I think, you know, it is generally a good thing to have the state courts involved in looking at and understanding their state systems. And I also think it matters a lot, even if you try to think about what does it mean to take the legislature of the state out and separate it. It's like not that easy. It's not that easy to do. As one example, going back to the New York case that was at issue, I mean, that all came out of it was a constitutional provision, but to amend the Constitution in New York, the legislature has to pass it twice, not once, but twice. And then it goes to a referendum for a general vote. So does that count as the legislature having actually put in place the very thing that is at issue? It's not so clear to me that you really can break the legislature away and separate it.
I should say, though, Deborah, in response to your concerns, you know, there are already constitutional doctrines that constrain state courts and state actors in the context of elections, not just federal elections, but state elections. This is not from the US Supreme Court, but in the courts of appeals, there are due process doctrines that basically say state actors cannot, in the guise of applying state election law, really distort it so much that they are significantly departing from existing state law or state practices in the election context. And state courts, as you know, we know that because they are elected and often on partisan tickets, you know, there is a risk of potential, you know, partisan manipulation. So to give you a concrete example, in Alabama, there was this long-running dispute over whether certain absentee ballots would or wouldn't count in the election of a justice to the state Supreme Court. The state Supreme Court decided X about that question, and the federal courts of appeals looked at Alabama practice and said, look, for decades, Alabama practice has been that these ballots are treated as not X. I don't remember which one was included or not included. And you violated due process. The Alabama Supreme Court, you violated due process because it's a matter of fundamental fairness that if voters vote under certain sets of rules, then the implementation, application, interpretation of those rules can't kind of pull the rug out from under voters. And there are other cases like this. There's not a lot of them. And there has always been a worry that this doctrine could get too expansive and could lead federal courts to start second guessing state election decision-making to too large an extent. That hasn't happened so far. These doctrines have been around for 30 some years or so. I kind of prefer, I mean, I definitely prefer that to the independent state legislature theory, because I do think there is a legitimate due process kind of concern that should apply to state elections as well as federal elections to constrain the real very extreme manipulation of the process by other state actors. So it's not as if we don't have any doctrine like that. It's not really as well known because we don't have a prominent Supreme Court case. But I think it's important to note in this context that due process does come into the picture here, regardless of anything about the independent state legislature theory.
And I'll just flag that every single party before the U.S. Supreme Court in Moore versus Harper and all of the lawyers opposing the independent state legislature theory articulated this perspective to the court and said that there is a role for the U.S. Supreme Court. It just has to be extraordinarily deferential. It has to be about fundamental fairness. And I think crucially, the doctrine that Rick is talking about is housed in the due process clause, which would apply both to federal and to state elections. But if the US Supreme Court were to transpose that and put it into the elections clause, it would only apply to federal elections. And there's reasons to be concerned about that I think we've already talked about, which is it leads to a sort of two-tiered system. And it also sort of embraces this independent state legislature theory logic, which is slippery logic. And sort of as we talked a little bit earlier, we can try and cabinet and draw different distinctions, and there are all these different versions that say it's, you know, it's this but not this, or it's this but not this. But at the end of the day, if the Supreme Court blesses that logic, who's to say where it's going to go in 10, 20, 30, 40 years?
I also want to say, by the way, you know, you've been talking about state courts and the right to vote provision, and state courts, you know, having been up till now, at least some state courts more protective of the right to vote. I do think it's easy to imagine state courts going forward that are going to use vote dilution doctrine, you know, as part of the right to vote, to constrain expansions of the vote. So I think we've been talking about it in the context that we're most familiar with, because that has been the major thrust of state court involvement under these right to vote provisions. But I don't think it's at all, you know, hard to imagine that some state courts will use these constitutional provisions to strike down, for example, expansive access to absentee voting that legislatures enact. So I think we should put that into the picture as well in thinking about this.
So I've got at least two more questions I want to make sure to ask. And one is totally unfair, which is when I say this, because I duck this question all the time, what is the Supreme Court going to do? By which I mean, right? So let me now posit for a moment that the court is going to decide this either on this occasion or at some point, right? So taking Rick's point, this is just gonna be decided. This argument has existed in some form since Bush versus Gore, when it's raised the first time in a intensely political partisan election context. It only gets 3 votes on the Supreme Court at that time, but Brett Kavanaugh is one of the lawyers on the Bush team who advances the argument in that particular context. Obviously, Justice Kavanaugh now on the court. So there is interesting support for pieces of this. One of the theories that, you know, how do you narrow this? How do you make it something other than the state legislature can say whatever it wants and nobody else in the state can say anything? One of the theories that was talked about, I think, in oral arguments in Moore versus Harper is the idea that, well, with the state constitution has a clear rule that applies, and the state court applies this clear specific rule, then the state court interpretation of state law, you know, applies. But if the state constitution is vague or non-specific or doesn't actually give sufficient guidance, we, the Supreme Court, will say what the right answer is. So I want to both ask, you know, tell me a little bit about the tea leaves. Did you get any sense from oral arguments about which way this is going if they do decide it? But secondly, how worried should I be about the Supreme Court? And I don't mean necessarily from a partisan valence in this space. What I mean is, holy moly, the Supreme Court of the United States is going to start saying what state law means in some sort of regular way. That's sure not what I learned in Fed courts about who says what state law means. Okay, so bat it whichever one of those you care to bat at.
Well, so to take the question about this vague versus specific constitutional provisions, in 2015, the Supreme Court upheld Arizona's redistricting constitutional amendment, which was adopted by initiative, so the legislature had nothing to do with it, and the legislature sued and said it's taking our power away. The Supreme Court upheld that 5-4, rejecting a ISLT-like theory. The 5 votes those 5 votes are not all on the court anymore. The majority opinion was written by Chief Justice, or the dissent, excuse me, was written by Chief Justice Roberts. So it was being decided today, it might come out differently. But one of the things I think the petitioners in Moore versus Harper, the people arguing for the ISLT, were trying to do is give the court a way to rule in their favor without requiring the court to overrule relatively recent precedent in this Arizona case. And so they make this specific versus general argument as a sort of a backup argument. and other people have made it as well. There are a number of problems with this argument. One is that Rick has talked about that. What about precedent, right? What if there's a lot of precedent that actually gives meaning to what on its face looks like a fairly general free elections or free and fair elections clause, but it's actually been developed over many, many decades. Does that
In the state courts.
In the state courts,
Yeah.
yes. So how do we know what is specific or general? But I think even beyond that, even with some of the specific state constitutional provisions where that's not clear that really the decisions that a state court would be making are any different from what a state court would be making in applying a free and fair elections clause. So in a case like Arizona, where there's a commission and it's all procedural, yes, okay, that's just procedure. But to take New York's Constitution, I'm not going to get the language of the Constitution right, I'm sorry, but it includes language to the effect that, if you please correct me, that redistricting can't be designed to overly favor one party.
It's like over particular candidates or particular parties.
Right, so it's an anti-gerrymandering provision. Figuring out what that means in any particular map is really not meaningfully different, I don't think, from figuring out what a fair election map is, which is one of the things that's at issue in Moore versus Harper, or in the state court questions about Moore versus Harper. So trying to draw that line, I think, actually raises at least as many questions as it answers. And ultimately, I don't know how that line could be held.
After that is like a slightly sideways, but I can't help but draw analogies. There's this like, again, something a little strange to me about saying that because a state provision is unclear, that's when the federal court is going to come in and decide it, because actually like that's usually when in not, take it totally out of this context. If you have a regular case and there's a state law issue and it's unclear, federal court usually certifies that question over to the state court to decide. And so there's something a little backwards to me about that distinction going the other way here.
There's also, just to say one more thing, there's something very strange about the way the argument is constructed. The argument goes something like this: when it's a specific provision creating commissions or whatever, that the court is just applying that specific provision. But when the provision in the state constitution is something like a guarantee of free and fair elections, applying that is more like legislating. It looks like legislating. Now, if that's the case, think about what the US Supreme Court does all the time with all kinds of vague provisions of the US Constitution. The notion that it's somehow a legislative function by definition to apply broad constitutional language to specific situations really flies in the face of 230 years of constitutional history at both the state and federal level. So it's not really, in my view, a tenable argument.
One thing I was going to say about this, I think it's relevant here, is that the pandemic and the pandemic election, has created a lot of the context for all of this. And in particular, during the primary phase of the 2020 elections, which took place, very early on in the pandemic, Wisconsin had its important primaries in April of 2020. States moved their primaries several months down the road because of the pandemic. Federal and state courts did a tremendous number of things changing election law that they normally probably wouldn't have done, because the pandemic just, broke on the system. The legislatures didn't necessarily have time to figure out how to adapt the primary system, to these new threats. We didn't understand the threat all that clearly. Suddenly absentee voting was going to have a massive number of people, going that route. We didn't know if we'd be able to actually stand up polling stations, because we didn't know if people would be there to do the poll work. We didn't know, we couldn't use schools, we couldn't use churches, some of the standard places we do polling. And so courts, the way I put this, they exercise kind of emergency powers, if you will, during the primary phase of the election, which is not a power that, you know, courts, certainly federal courts, sort of normally have. I mean, they didn't use that language, but I think it's a way of understanding it. And I think that's, and some of that continued into the general election, but not that much, because by the time of the general election, a lot of legislatures had actually legislated on these issues. There was more time for appellate review, and the appellate courts were putting a kind of a damper on all this. But I think that feeds into the desire of some of the justices on the court, you know, to clearly consider this issue very seriously. And I think we sort of lose track of that because, you know, we're kind of past that. But I think it's important to remember, you know, what the legal side of the primary phase of the election in particular was. You know, on your question about Bush v. Gore, so that gets into the complexities of the different versions of this doctrine, but the concurrence of the three justices there, which Justice Rehnquist authored, Justice Thomas joined, Justice Scalia, was based on the position that state actors, just in interpreting election law, this is not about the state constitution, can't stray too far from the text of the statute without violating the federal constitution. It would not, that's not an issue in this case. It wouldn't surprise me if there is a majority on the court currently for a view like that. What's an issue in Moore, though, is this whole issue about the role of the state constitutions and whether they are taken off the table in federal elections, either in whole or in part, if courts are enforcing these more general provisions. And I don't know if there's a majority for any version of that view. Certainly the only one that's in play now after the argument is the one Carolyn and others have discussed, which is, you know, perhaps the court's inclined to the view that if a provision is very general, it can't be enforced by state courts because that intrudes on the legislature. But if, as in New York, you know, the Constitution bans partisan gerrymandering, then enforcing a provision that's specific like that is a traditional kind of judicial role. And I don't know if there's a majority for that view. I think, as everybody has said, that opens up, it's not as sweeping, but it would create tremendous uncertainty. There'd be lots of litigation about what that boundary is. It's very hard to see how you can give any coherence to how specific a provision is. To be specific enough, is a right to vote provision in a state constitution specific enough to survive this doctrine? So I actually don't know if if they reach the merits, if there is a majority in this context, even though in the Bush v. Gore context, perhaps there is.
So I can't pin anybody down on what the court's going to do. That's fine. I surrender. But right. I mean, one of the interesting and alarming to some extent prospects this raises is that we might get a decision on the merits, but it'll be maybe we'll have a plurality, 4 votes for one, and we'll have so whether that clarifies the situation, I guess it will be a question we'll have to deal with. Okay, I want to do one more question, and then I promise I will let other people ask questions if they have them, because I have a whole other list that I haven't gotten to. So, but I will let you guys ask questions. But one more, which is just the how do I not descend in denialism? And let me channel views I have heard students express in different settings, and that is, we can't do this in a moment of nobody can do this in the current moment of intense political polarization, right, across institutions. And there is no structural answer to this question. There is no structural solution to this question, because every potential decision maker, right? We tried independent commissions to take it out of partisan legislatures to figure out how to draw the lines. In some places, that's worked fabulously. In other places, not so well.
It's our first run at it.
Yeah, look, no, I'm not saying, but right. So some places this worked well, some places this didn't work well the first time around. There's the U.S. Supreme Court and federal courts, obviously, that the Supreme Court itself right now, the product of intensely polarized confirmation hearings over the last several decades. State legislatures, it depends very much on the state, what it looks like. Right. In other words, everywhere I look, it's turtles all the way down. It's just us, right? How do we solve this? Is there a solution here that is something other than fix polarization? And if that's the problem, tell me how to do that.
That's like not really that's a big question.
Yes, it is.
Well,
but if we can't talk about it, I don't know.
So
who
I
can,
think
yeah.
I think about this a lot, and I talk to my students about this a lot. So I'll take a crack at least some of it. First of all, you have to ask yourself, what's the alternative, right? I could become a nihilist and like go into my cave and never come out. I have my moments, but that doesn't strike me as a real alternative. A second thing I'll say is take the long view. When I teach constitutional law, I always show part of a documentary called The Road to Brown, which tracks the litigation strategy that took decades to get to Brown versus Board of Education. One of the architects of that, Charles Hamilton Houston, died before Brown was decided. So, it's not good that it took decades, but take the long view. And I guess the third thing, I can get very preachy, so I'm going to try not to do that.
You're doing great.
That where I think solving polarization is important. And one of the ways I think to think about how to solve polarization is to ask the question, why do we have law and why do we have democracy? And in my view, one of the very big reasons we have law and democracy is so we don't kill each other. And I think, maybe I'm wrong, that there's probably pretty broad agreement that killing each other is a bad idea. And so going back to some of these first principles and trying to have conversations across partisan lines about them, I think is going to be crucial going forward. It's not easy. And I don't want to be Pollyannish and say, so just all of you go out and, and it'll be just great. But I think we have to think about those really bedrock questions. Like why are we doing this? And hopefully that will help steer us in a direction where we can actually live together and not kill each other.
Solutions?
Well-
I don't have a solution. This is another perhaps pessimistic, but in a way turning it back in a good way. I don't dispute that if everything either is or feels hyper partisan now, and I do think the COVID, I do think Ruth's right that the election, how much chaos there was because of COVID during the election, really influenced how we sort of feel about this right now and how we got here. On the other hand, one thing I'll say is I don't think that litigation and high stakes litigation over redistricting and elections is new. And if you think about the case, the census cases, it's like a quote from one of the cases, it's like the sun rises every morning, every 10 years after the census, there is always big litigation. And so I think in some ways that's the way it is when you have a system that, is hopefully democratic and people feel like that they're winning and losing is at stake here. I think there is always going to be a lot of litigation.
So many things I'd want to talk about here. One thing I'll say is I was part of the legal team representing Common Cause in the Supreme Court on this Rucho case, in which we were trying to get the Supreme Court to hold partisan gerrymandering unconstitutional and actually apply it in that case, which is also from North Carolina. I think we would have been much better off with a uniform national approach to the issue. I don't know if the court looks at this differently at this point, but having these fights state by state often with elected judges, Some states have commissions, some states don't have commissions. I think that this is an area when we're talking about congressional elections where some national uniformity would be a good thing. One minor positive kind of spin on things is I was involved in the successful bipartisan effort in Congress to enact the new Electoral Count Act after we learned in the 2020 election, or relearn for academics who had studied this, all of the vulnerabilities in that statute from the 19th century. There was a lot of talk when we began this effort. A bipartisan group of academic experts on the law, this is delusional. You'll never get bipartisan agreement. This is a trap, et cetera, et cetera, et cetera. Sort of in Carolyn's mindset, we pushed forward on that. And actually, it turned out there was substantial bipartisan support for this reform, which I think makes the 2024 presidential election more secure legally now than what we had before. I write about things we might do on polarization, but it is a huge issue, and the institutional reforms I favor, like the top 4 primary with ranked choice voting in the general election, which Alaska voters adopted, which would reward candidates who have the broadest appeal in the electorate. I think those would be good developments. But you can't cure something as deep as the nature of our political culture right now with a few institutional tweaks here and there. You can maybe at the margins help a bit.
The reform of the Electoral Count Act is actually a really amazing current example of bipartisanship. And I was recently reading a news article about how much more coverage polarized behavior among members of Congress gets than in the press than any example of bipartisanship at any level. So that's an important reminder. Okay, I promised it is time. If you have questions, I'd love to. I can go on. So if y'all are going to be shy, that's fine too. But truly, it would be great to hear, especially students, if you have questions that you would like to have answered. See, they're shy.
You have to give them time.
Okay,
Teachers.
great.
Hi. So you guys were talking about why we're dealing with so much voter litigation recently, but I guess my question is more why this case now? I know post Bush v. Gore, this idea kind of came into circulation, but I feel like I never really heard of it as in a theory. It was always kind of this far-fetched illusion. And if you read the Constitution, from a matter of statutory interpretation, how does the state's legislature, that, phrase turn into this massive idea and shift in what, a lot of us as law students think as every state has executive, judicial, legislature. So how is it that these two words all of a sudden, is it just appetite on this court? We know they kind of don't really care about standing issues, at least in my opinion. I'm just I understand voter litigation in this era, but why this case now?
Well, I think it's because in 2020, Republicans thought it was to their advantage to push the issue. Smart lawyers in high stakes litigation look for all the arguments they can find. And there were a series of cases in large part because of the pandemic and the types of things that state courts were doing in response to what was happening with the pandemic, and the post office, which was related to the pandemic, but not entirely. State courts were exercising their emergency equitable powers in ways that were unusual, not that they were lawless. No, I don't think they were at all, but they were unusual. And in situations where the Republican Party didn't like the results, this was an available argument. So I really think that's why. And I don't, I think if in a different set of facts on the ground, it wouldn't have come forward in the same way, or maybe it would have been brought by the other side. I don't know, but I think that in my view is the main answer for why it has emerged in this moment.
I think another piece of the puzzle, I agree with what Carolyn is saying, but this is, I think, also a story about the shadow docket, which is, the set of cases and motions that the U.S. Supreme Court hears, other than the ones that are sort of argued in the limelight. And 4 of the justices who are sort of championing this theory used the shadow docket in and around the 2020 election to effectively ask litigants to bring this theory up to the court. And so there's a sort of interplay there, not just clever lawyering, but a sort of feedback effect where the justices who want to enshrine this theory in law are asking the clever lawyers to bring the case, which they then do, which then tees up the Moore versus Harper case.
Okay, ice has been broken. Thank you very much. Other questions, folks? Oh, Professor Pollack. Yeah, no, sorry. Please.
This might be a naive question, but if one takes the view that the Supreme Court wants to hear fewer of these cases in the run-up of an election, it's fast, it's a lot going on, it's all shadow docket, that, as they say, they don't like it. It seems to me that one way to ensure that their wish is not granted is to put federal courts more at the center of election litigation, right? That one way for a Supreme Court that wanted to have less of a role in the heat of an election to achieve that is to say, here, states, do more of it, and then we'll do our traditional thing where on interpretation of state law questions, we don't ask, we don't get involved in that, right? And so to hear justices sort of articulate in opinions, in these shadow docket opinions, like, this is terrible, you're making us do all this last minute stuff, please give us more of it, seems hard to sort of reconcile. It's like the old joke about, like, you know, such terrible food and such small portions, right? And so, like, where's the lie, right? Like, is it that they, like, actually are happy to have more election litigation? Is it they don't foresee getting more of it? Like, where's the or is it not as inconsistent as I'm articulating it?
I mean, I can't get into the mindset, but you know, one way of looking at it is, if the court lays down the principle with constraints, that other actors in the system are going to kind of internalize that. And, you know, maybe state courts will hem themselves in more, or the lower federal courts will have a lot of the burden, and the Supreme Court can decide which of those cases, if any, it wants to take from the lower federal courts. But, you know, as we've said, I do think that opening up this notion that there are some constitutional provisions that can't be enforced or can't go too far from the text of the provision, you know, would certainly trigger a lot of litigation. But I don't know, the court doesn't worry so much. You know, it can control what it does. So it can decide how engaged it wants to continue to be after laying down some set of principles, and how much it wants to pull back and let the lower courts deal with the issue, which they do all the time.
Well, to be a little more cynical, you know, there's one critique of the current court is that they are amassing power in a variety of ways and taking that power from a variety of other actors, whether it be Congress or the executive or the states. And this would be an example of that. I think that the independent state legislature theory is a complete misnomer, because I think, in fact, what it does is empower the Supreme Court. And that you don't want all of this, I think, is not a bad argument, because I think that at least ex ante they don't. I think what happened during 2020 is that in the moment of intense partisanship, where some people felt that these state courts that were democratically controlled were going all out to allow, you know, mail-in ballots that weren't otherwise permissible and extending dates, et cetera, et cetera. And we're doing that. I think there was probably a view among some, possibly some justices, that was an attempt to favor the Democratic candidates. They felt they couldn't restrain themselves from wanting to get involved. I would like to think that in sort of the cold light of day, with more time having passed and with way more information about the history that completely debunks, which we haven't even talked about, that totally debunks the ISLT, that they would come to a different view, but hard to say.
Okay, we have time for one last question, I think. And if you don't ask it, I will. All right, so I invite last minute thoughts, but I'd like, you know, of any kind, but short of asking you to tell me what the Supreme Court is going to do, because after this conversation, I feel like I have actually less of an idea than I did coming into it. Thanks very much.
That's how my students usually leave class.
Yeah. You know, what the next 2 years, you know, we're coming up, we got through the midterms, we're coming up in a presidential election. There's every chance it looks a lot like the 2020 presidential election, short of COVID, knock on wood. But in terms of the candidates and the political conditions in the country, what should we anticipate about the role of the courts in the 2024 election? Oh,
There's going to be a lot of litigation.
Yeah.
That I feel very confident in that prediction. And yeah, and whether it all goes, you know, where it starts in state court or goes to federal court, the exact path it takes, I don't know, but it's not, and it's, you know, the use of courts to try to resolve these big important questions. It's not just limited to the election context. I'm teaching a class with the Illinois Attorney General, and as part of at my law school, and as part of that class, we've been looking at the rates of attorney generals suing the federal government. And it's gone up dramatically since really the beginning of the 2000s, a little bit in the 90s. And what's even more dramatic is how much more partisan that litigation has become. It used to be that when states sued the federal government, it was more likely to be a kind of bipartisan, get out of my way, federal government, let me do what I want as a state kind of set of litigations that could really cross party lines. And that is not what we see now. So that's just another, I think in some ways, right, it's all a reflection of people who are very polarized and, as Rick said, see every election as existential, are using the tools at their disposal. And these are the tools.
in other words, a good time to be a lawyer. Important time to be a lawyer. So I want to invite everyone to join us in the folks who are here in the room. I'm sorry for those on the webinar, you miss it. The folks who are here in the room can join us in the lobby for some snacks. But first, please join me in thanking the panelists for wonderful